Courts in Alabama recognize legal and physical custody. Of course, legal custody is who gets the right to make decisions for your children. Physical custody is where the children live most of the time. A lot of parents now will share true joint legal and physical custody, which means the parents have equal rights to decision making, and then they spend equal amounts of time with the children. As you can imagine, sometimes when parents share equal decision-making responsibility, it can lead to a problem, because the truth is, if you and your spouse could agree on everything, you might not get divorced anyway. Oftentimes, courts like to designate a final decision-making person in a custodial situation. So even if you share joint legal custody and you both have input into the decisions, you can't always agree. So you need somebody who gets to make that final call. Those areas are going to include education, religion, medical issues, social and cultural issues, all of those kind of things. You need somebody who's going to have the final say, because maybe you're Jewish and you want to make sure that your children are raised in that heritage. Or maybe you do not believe in vaccines and you want to make sure that your children do not take vaccines. Or perhaps maybe you have a really strong feeling that your children should be in a private school and not in the public school. There are important reasons why you need to make sure that even if you share joint legal custody and joint physical custody, that you get certain areas designated that you can be the final decision-making parent if that's necessary in your situation. It may not always be, but if that's a concern for you, that's something you need to talk to your lawyer about. What is in the best interest of a child? As a parent, that's always supposed to be the primary thing in our mind. What's going to be the best thing for my child? When you go into a court, the judge is also going to consider what is in the best interest of your child or your children. Those can be all kinds of things. Do you have the financial ability to care for those children? Are the children in a situation where they're comfortable being there with you and they're able to grow up in a normal, thriving environment? Or issues that you have like addiction, or maybe anger management problems, or maybe you don't have stable housing or employment. Those kind of things can affect the best interest of your children's lives. And so when we're in court and we look at the best interest of your kids, the court is going to consider a lot of factors. It is going to be financial. It is going to be social. It is going to be educational. It is going to be medical. There are a lot of times many parents, for whatever reason, don't believe a child needs certain medication the other parents had prescribed by the doctor, and they refuse to give that medication to the child. The judge may find that it's not in the best interest of your child to continue to live in your care if you're not going to give the medication prescribed by a doctor. And so when we look at the best interest of a child, there are a lot of factors that come into that. You need to consider, if I was the judge, would I think that my decisions are in the best interest of my children, or am I acting in a petty and silly way with the other parent because I'm trying to win versus really looking out for the best interest of my kids? You probably want to know, how do I change a custody order? We've been to court in the past. The court has already determined that we have this certain custodial arrangement. Now something's happened, I need to change it. There are two ways that we can have custody changed in Alabama. The first and the most common way you might hear about is McClendon. Now you don't know what it is. You've heard of McClendon, maybe you've not heard of it, and you wonder, what is that? How does it apply to me? So here's the deal. A long time ago, there was a family named the McClendon family. Their case went all the way up in the appellate courts, and their case determined what is now our standard for how we change custody in a traditional custodial arrangement where we're trying to change custody from one parent to the other. The other issue is we're going to look at the best interest change if you share equal time with your children, okay? So when we look at the McClendon standard, the law says there has to be a material change in circumstances in which the benefits to the children by that change are going to outweigh any natural burdens that are going to come with a change. On the other hand, if we have a best interest change, that is a different burden to meet, and that's typically going to be when parents share equal time and equal decision-making authority with the children. We're going to try to prove to the court that something's changed that would be in the best interest now of your children in order for you to have custody. So you can change from joint custody to primary. You can change all the way over from one parent having custody to something's happened, and now we're going to flip over and the other parent has custody. Sometimes something has happened and now this parent, maybe they're working out of town every other week, and now we're going from one parent having custody to joint custody. So really, any combination of those issues can cause a change of custody. And we're going to look at McClendon if one parent has had custody or changed to the other parent. And it's not always a parent. Maybe a grandparent or a friend has had custody, and now you want to obtain custody back. McClendon is going to apply there. But again, if you share equal time and equal decision-making authority with another person, then we're going to look at the best interest. So both of those ways are ways that we can change custody in Alabama. So you're divorced. You have a custody order, and now things have changed in your life, and you need to move. Maybe you need to move an hour away because of a job. Maybe you're moving down south to go to the beach, or maybe you just need to move across town and you wonder, can I move with my children after this custody order is finalized? Well, the truth is, maybe so. We need to look at a lot of things. If you're going to move 60 or more miles away from where you live right now, then that's going to fall within what we call the Alabama Parent-Child Relationship Protection Act. You probably have heard of the Relocation Act, okay? And all that means is if you're going to do that, you have to provide the other parent 45 days advance written notice. And in our office, we typically have people who will call us and say, hey, I'm going to move. Can you help me with this letter? And so we have a little form letter we can help you with that simply lays out all the things the law is requiring you to tell the other parent. It's going to include things like how you anticipate this move is going to affect the other parent's visitation schedule, where they're going to go to school, where you're going to live, what phone numbers you're going to use. A lot of things are going to go in there that are real technical, and it's laid out in every custody decree in Alabama has this relocation statute listed out in there. So if you're wondering, can I move? You can even do it on your own. Pull out your order, pull out your settlement agreement, and look at it. Tells you line by line the things you need to include in that letter. Just make sure you send it at least 45 days in advance before your move, because the deal is the other parent will have 30 days after they receive that notice to file an objection to it. A lot of times our office has filed an objection to relocation and had the court stop the kids from moving. The court may say, ma'am, sir, I don't care where you live, but your kids are in this county, your kids are going to stay in this county. It is possible, if you follow the rules and go through the right procedure, you can move with your children after a divorce or after a custody order. And it happens all the time. Many times I would encourage you, take time to talk to the other parent. You may think, I don't want to talk to them. We hate each other. We're not going to get along. They're just going to tell me I can't go anyway. Whether you talk to them or you don't talk to them, they still have a right to file an objection with the court. And so you may cut down on some of the friction between the two of you if you just take time to talk to them. Even if you know they're going to be mad, even if you know it's going to be an argument, just tell them, hey, I'm going to move. Here are the reasons why. And if they hear from you and they kind of understand your rationale, and you're not trying to, jump ship and run away with the kids. They know you're not just trying to keep them from being involved in the children's lives at all, but you're able to explain to them the plan. Hey, the schools are really good where I'm going to go. I'm going to have this job opportunity where my income's going to be double what it is right now. Or maybe even, I've had these issues up here where we live. I need to move over here, and here's why. That may cause the other parent to be more understanding, and they might even surprise you. They might say, you know what, that's great. Why don't we work together to figure out something that we can do to share time with the kids still, but you can go move and I'll stay here. You don't know if you don't ask. So it is possible to move after a divorce or after a custody order. There's a rule you have to follow to get it done. If you're going to move within 60 miles, you don't have to do the 45-day letter, but you still need to always let the other parent know where the children are. You think, I don't want them to know where my kids now are. It's none of their business. They can know where the kids are on their time. Well, that's not fair. You wouldn't want their location to be kept from you, and it's not fair to keep their location from the other parent. So they have a right to know where you live, where the kids are going to sleep at night. Even if you're moving for a few weeks because you had a house fire, you got to go stay somewhere else. The parent has a right to know where your children are. You need to make sure you follow that, because again, many times it's going to cut down on conflict between the two parents if you're open and honest in advance with the other parent. If you're in a place in your life right now where you need to move with your children, or maybe you think custody needs to be modified, maybe child support needs to change, maybe something has happened in your life that is going to require a change in the physical or legal custody of your children, call us right now. We'd love to help you.